without prejudice to the right to present a petition to an election court, an habeas corpus. Every candidate shall accept the final outcome of the election and the Commission's declaration and certification of the results thereof. That's what the first petitioner signed to. He ought to abide by it. I rest, my lords and my ladies, that you dismiss this petition with cause unless you have questions.
Thank you, Mr. Kinendri.
Thank you, my lords and my ladies.
Okay, let's go.
My lords, my ladies,
Honorable Attorney General, please hold your horses.
as you direct, my lord.
Yes, let's get the rejoinder first.
Okay.
Then you come last.
My lord, as you direct.
Thank you. Honorable Warengo.
My lords and my ladies, in our rejoinder, we will do the following. First, my learned friend Mr. Tiende will address your lordships and my ladies for 10 minutes.
Yeah.
And then my learned friend Mr. Firoz Norji will address the court for about 40 minutes, and I'll have a balance of about 5 minutes or so.
Very well.
So,
if it may please, my lords, I will be very brief for this part. My lords, I will restrict my reply essentially to the first and second respondents, but generally say, my lords, that in the presentation by all the respondents, they have created an imaginary case for the petitioner and proceeded to answer it. Cases we have not presented before you. I will not comment on that part. My lord, allow me to say with great respect that between the 8 lawyers representing the first and third respondents, they have treated not only this court, but the petitioner and the Kenyan voter with contempt. My lords, first, the essential question that was demonstrated and must be asked were Form 34As generated, scanned and transmitted electronically and manually to the National Tallying Center, as the law requires. In their written response, paragraph 20D and 24A, they say they did. All of them. In their address to you, they admit they did not transmit at least 11,000 of those forms. But then they do not stop there, my lords. They tell you that whether those forms and images were transmitted or not is irrelevant, because the announcement was based on Form 34Bs. By so doing, they admit to have breached the law. By so doing, they endeavor to run away from the results transmitted electronically. My lord, they then tell you, and it comes to the question therefore, that if it was manual, it was not based on the electronic transmission, were all the Form 34As transmitted to the National Tallying Center by the time of the declaration? To that then the answer no. But they add, however, all of them were eventually transmitted after the declaration of the final result. And to that then it invites the necessary legal question that if at least 11,000 from 34As were not at the National Tallying Center. On what basis did the chairman declare the results? And then the chairman says, my lord, it was on the basis of Form 34B, as received from the Constituency Tallying Center. And then they add, my lord, contrary to the law, seeking refuge in the minor KI decision, that there is no obligation on the chairman to confirm that the results shown on 34B reflect the results on Form 34A. My lord, that is contrary to the minor KI decision. The KI decision says the results as pronounced at the polling station is final, which means, my lord, what the chairman must look at is Form 34A, and then check without varying that the entries match with 34B. Then he can proceed to declare. He did not do that in this case, by their own admission. But they say it does not matter because they eventually arrived anyway. My lord, it begs the legal and legitimate question, what was the hurry? The law allows the chairman 7 days. He hurried to announce on the 3rd day, 2.5 days. What was the hurry? In the end, my lord, the results are neither based on an electronic transmission, nor are they based on a manual delivery of Form 34As or Bs. It's even worse, my lord. The chairman has the audacity to tell, my lords, in the response, that he saw all the 290 Form 34Bs. Then here he comes to admit that he did not tally the ones for Nyando. That is grave. That is very grave. My lord, the IEBC tells you, the question is posed to them, that the law requires that the results be transmitted immediately as they come in, randomly. As we demonstrated, my lord, the results that were transmitted and displayed did not come randomly and certainly did not indicate the respective polling stations. The third respondent has endeavored to demonstrate to you the polling stations that transmitted the initial results. How the third respondent got that information is up to them, but it is not information from the public portal, and that is not disputed. But more importantly, the law requires that that information, that result must be verified and accurate. It must reflect what is in 34A. It is clear, and it was demonstrated, my lords, that the results in this case do not reflect that. What does the IBC tell you? IBC first, in their papers, they call that is a mere statistic. It is irrelevant. In court, my learned friend Mr. Nyamodi says that is mere data. When pressed by this court, it says it is a figure that was formerly called provisional results. My lords did ask them, so what are they? They could not answer. My lord, these are supposed to be results by law, transmitted electronically, and you cannot transmit inaccuracies and run away from it. But more interestingly, and sometimes this happens when you have many councils, to the very basic question, were all the 34As transmitted eventually to the National Tallying Center? My learned friend Mr. Nyamodi says yes. Issa Mansour comes later and says no, there is no requirement for delivering Form 34As. Hence the question of returns is irrelevant. My lord, this is the same IEBC addressing you on such an important matter. This IEBC, my lord, wants you to believe that the chairman has no role in verifying what he declares. That because the minor KI decision said the results are final, that the chairman must robotically pick them and pronounce without verifying. I submit, my lords, that that cannot be the position. But more interestingly, my lord, and I have 2 minutes to go for my own time, they transmitted these results to the entire public. A member of an expert, given those very results, analyzed them and presented them to you. not the IEBC, not the third respondent, have disputed the entries that were provided to you. Those entries tell a story through a regression analysis, an impossible story. What does the IEBC tell you and tell this country? That is Pythagoras' theorem. People paid by the taxpayers. Lawyers engaged who will be paid by the taxpayer. Some of whom are already public officers. That is Pythagoras' theorem. My lords, I respect you to submit that this court and the people of Kenya must be treated with a little more respect. My lord, lastly, and this is my closing on my part, the issue and the question that my lords did ask, the difference in presidential votes and all the others. And my lord, we did show that the difference runs into 577,000 votes. And my lords did ask the respondents the question, what accounts for that? The IEBC, my lord, through its lawyers, stand in this court and tell you with a straight face that the difference is because of the diaspora votes and the prisons votes. Their own documents show that the total number of diaspora votes is 4,000, their own documents. We are not even asking how many voted. The total number of registered voters in terms of the prisoners is 5,000. The exact number, my lord, is 5,528. Diaspora is 4,393. And they stand here, my lord, to tell you that those numbers, which come to less than 9,000, is why the president has 570,000 votes more. My lord, I submit that the contempt and unseriousness with which the IEBC has treated this petition and this court reflects the unseriousness and the shoddiness with which they treated the presidential election process. Thank you, my lord.
Thank you. Thank you, Mr. Kennedy.
Thank you, my lord.
Yes, Mr. Norwich.
Thank you, my lord. Members of the court, my lord, may I turn first in reply to my learned friend Mr. Gatia's submission that the unique provisions of the election of the president is what we should be looking at. And he said that in that there was the provision to tally and then to declare the result. And he was referring to Article 138, 3, Sub-Article 3, Paragraph C. But he left out one very important part of that provision. And the provision is this. After counting the votes, it's 138, 3C. After counting the votes in the polling stations, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the result. So that right in there, right in the presidential election special provisions, is the necessity for the returning officer, the second respondent, to verify before he declares. And we submit that this indeed was not done. We go a step further, my lord, and we say it could not have been done. This is the important consideration that we wrote to the IEBC on the 10th of August, the day of the result, and that is to be found. It has already been submitted by my learned friend, Honorable Otiende Amolo, in his submission. It is the letters are to be found in the petitioner's supporting affidavit, Volume 1, Volume 2. I'm sorry, Volume 2. And at page 207, this is what we wrote to the IEBC saying, you informed the Kenyans and the world at large that IEBC had received over 40,000 forms, 34A, and about 170 forms, 34B. We have requested IEBC for all these forms for purposes of verification. Members of your Secretariat have informed us that they can only avail 29,000 forms of 34A. So that is a gap of about 11,000 34As on the 10th of August. As at 11 p.m. of 10th August 2017, which is now after the result. So after the result, my Lord, 11,000 34As were not with the IEBC. They could not avail them to us. Kindly request the Commission to expedite. Then the IEBC didn't reply immediately to this, and on the 14th of August, we wrote again to the chairperson, which is on page 208, the next page, my lords, my ladies. This is a follow-up of our letter of 10th August. Until now, IEBC has only furnished NASA with 29,000. So that is close to, my arithmetic isn't the best, 12,000. Forms 34A and 114. We urgently require the unsupplied 10,000 form 34As. So even between the 10th of August and the 14th of August, those missing 11,000 34As had not been supplied to us. We wrote this letter on the 14th. They replied then on page 209. To the Deputy Presidential Agent from the CEO, Commission Secretary Mr. Chiloba. Reference is made to your letter of 14th August requesting to be supplied with the remaining forms that were not supplied earlier. The Commission is in a position to provide all the requested form 34B immediately, so they could give 34Bs immediately. We are, however, not able to supply Form 34As at the moment, but the same shall be availed to you as soon as possible. My lords, my ladies, this is now 4 days after the result. If they do not have, those are not available. I use his words, they are not able to supply 34A at the moment. How then did he get to the result? I will come back to this aspect, but at this moment we submit, in reply to the submissions made on Article 38, that the returning officer, the second respondent, did not verify and therefore did not comply with Article 38, which is the article that the respondents themselves say had been followed and is to be followed. And we say that this therefore could not lead to a result, and that the declaration of result was therefore in violation of Article 38 and could not give forth of a lawful result, a lawful declaration. I'll come back to these forms in a short while and turn then to the question, where were then these forms? Why were 11,034 A's missing for 5 days after the election, 6 days actually, 6 days after the election. And we saw here a chart by the respondents of what happened at 5:07, what happened at 5:08, 9, 10, etc. What would have helped the court would be to have a chart of what happened step by step. Let us take the 34As in the best of conditions, my Lord, giving them the benefit of any doubt. And 34As were supposed to come from these 40,000 polling stations to the tallying center, and then from constituency to the national. And when they arrived there, presumably immediately after the counting, and my learned colleague Mr. Omolo has pointed out, what were the means of transmission? That already creates another area of hopeless doubt, which has not been cleared. But let us assume that they were transmitted electronically, and when that predictably failed, they were going on with another system. But whatever it is, 34As had 41,000 34As had to reach the National Tallying Center, and they reached on that day. Maybe they reached on the 11th, on the 10th. My lords, then we do not know what happened to them. On the 14th, on the 11th, they're not there. 12th, they're not there. 13th, they're not there. 14th, they're not there. My lords, they have gone into the IEBC headquarters, and then we hear no more about them until later, and I come to that. My lords, there is in the mid-Atlantic Ocean near Bermuda an area where ships that have gone into this area never seem to come out, and nobody knows what happens to them. This is called the Bermuda Triangle. And the Bermuda Triangle is notorious for the absence of knowledge of what happens to ships that go into this triangle. My lords, we have emulated that, and this is the Beauma's Triangle. 34As come in, and then they disappear. We don't know what happens to them. My lords, this is not law, this is not accuracy, this is not verifiability, this is not transparency, this is something, unfortunately, that can only give rise to a very questionable sequence. And it is this, my lord. Everybody knows, and the Honorable Mr. Kerry, who is a gallant and honorable person, himself thought that it was very simple. All you have to do, if there is a problem in the result, go back to the 34As and the discrepancy will come forward. And those people who have an interest in this, those who have an interest in this, know that that's the purpose of 34A. We were closing gaps everywhere, loopholes being closed. But, my lords, suppose you do the reverse. Instead of changing the result to the 34As, suppose you change the 34As to match the result which you have given. Then, when people go back to the 34As, the result, false result, and the 34As will match. But only, my lords, if they are false 34As. And my lords, in order to have 41,000 false 34As, you need time. You need different
Sorry, my lord.
methods.
I know I'm not supposed to interject. But is that not a new case? Is that not a new angle in terms of changing the time?
Sorry, what's your...
The issue is now, in terms of changing the time, my client has an interest because now you would need the time to change, that's what I'm hearing, the Form 34As to match, as it were, with the Form 34Bs. Why I say that is that my client's agents were present when the signature was being done, or rather appended to the Form 34A. That's yes.
My lord, he is not a party to this petition. He is not the custodian of the interests of either the person who's been declared, or the IBC, or the petitioner who is the candidate. He has no standing to make any interruption, my lord. My lord, I go back. So that the question is, you need time, and that is what may have happened, that is what could have happened, because, my lords, your lordships and your ladyships have no other evidence before you, and the only person who knows what was being done is the second respondent and the first respondent, and they have not chosen to explain this Boma's triangle missing, and the law, presumption in the law comes into place. A person who has special knowledge or the custody of evidence in his own hands and is not producing it to the court, the presumption is that the evidence he is holding is adverse to him. And that is the presumption that the court must draw in law, in common sense. My lords, your lordships and ladyships every day in your long careers sit and listen to lawyers and litigants coming before you and constantly twisting. But here is the question of hiding, and you all have enormous experience to know that litigants can do this and often do this. And you all would look beyond what is being put forward and say, what is actually going on? What is the common sense? What do we as people of the world see in this? And that is what is happening, we submit, that Form 34As were being held over for a purpose which can only be unlawful. I do not have to make any accusations, my lords, my ladies, against anyone. The mere fact of not disclosing what had happened to this can draw only one conclusion, that it is unlawful. And that is not a free and fair election. My lords, my ladies, not only did they not verify, but now we come to the other part of the evidence that Mr. Otiendo Amolo had brought forward. Why should there be Forms 34A, which when put under the machine show different names? That some of them show a barcode, some don't. Some do show somebody else's use of these things. So why was this necessary? If these were original 34As, then there was no reason for the forms to be other than the forms of the IEBC. And secondly, there would be no reason for them to vary amongst themselves. One with this name, one with another name, one with a different code, one with a different name of the candidate, and so on. So that, my Lord, the evidence that they themselves have given us, which we have now passed on to the court, shows, my Lords, that this is a management of the election which is heavily unlawful in places. It is more than careless. This is not how elections ought to be anywhere near being carried out. And we submit that from this missing evidence, there can be no declaration of the result that can be lawful. And it goes a little step further, my lords and ladies. It is this type of presentation which the respondents have done on a long time is not at all unusual. And to stop that, to stop the chairperson, returning officer, tallying officers, to say, we got them, we put them together, and we announced them. That was exactly what happened in 2007. And it led to a predictable result. And, my lords, the law is, therefore, that when an election official makes an entry into any document, in this case an entry into a declaration of result, he must have a belief in the truth of that entry, so that he cannot say what Mr. Honorable Kivitu said. Mr. Kivitu, do you think the President has won this election fairly? And he said, I don't know. On international television. And that is what they say, because, my lords, there is so much silence. Mr. Moller was right. They came and said the election was held with secret ballot. We had never said no, but they put it forward. We didn't do this. We had never said so. But they never come and say, we believed in this. Because they know that that statement in a court of law or in any other place is actually, my lord, an entry which does not carry that belief in the truth is actually now a criminal offense under the Election Offences Act. We have not sought any such declaration from the court, but we are saying that a conduct by the returning officer, which is conduct which is forbidden by statute, is of itself unlawful. Whether he is charged, not charged, whether there has been a claim for it or not, it is an unlawful. It's an unlawful step taken by him. My lords, can this